He brought his mistress to family court because he wanted his wife humiliated before the hearing even began. By late that same morning, the mistress was under oath. The judge had serious concerns about hidden money, and the postnuptial agreement he thought would protect him was doing something else entirely. It was quietly assigning every future consequence to the man who had insisted they were his alone. If you think this story is about adultery, it is not. Adultery embarrasses people. Paper ruins them. And Grant Hale had signed far more paper than he understood. The detail people remembered later was not the affair. It was the entrance. Grant Hale walked into the courthouse with the composure of a man arriving to collect something already decided. Not hurried, not defensive, not even especially careful. And the woman on his arm was not behind him, not in the gallery, not waiting outside with enough distance to preserve deniability. She was on his arm, cream leather heels, a narrow heel, too delicate for governmentile, too deliberate for a morning hearing. He brought his mistress into family court the way some men bring an opening statement, to set the tone before a word had been spoken. That was the detail nobody forgot, not the clerk at intake, who looked up too quickly and then looked away, not the bailiff, who had spent 15 years watching wealthy people attempt variations of dignity and had seen very few choose humiliation as confidently as Grant Hale did that morning. Not the lawyers from other floors who recognized Sloan Mercer from redevelopment launch events and charity photographs, and understood instantly that the case had changed categories. And not Judge Lydia Shaw, who later paused over her reading glasses and asked only this: "He brought her into my courtroom?" Yes, he had. Grant Hale, 44 years old, founder of Hale Redevelopment Partners, a man whose professional life had been built on acquisition and whose private life had slowly begun to resemble it. He seated Sloan Mercer directly behind counsel table, where his wife could not possibly fail to see her. He wanted visibility. He wanted the room arranged around the fact of replacement. Most of all, he wanted Eleanor to understand, before the hearing even began, that she was no longer the central woman in his life, and no longer the central force in the room. He wanted injury before argument. He wanted spectacle before law. Instead, Eleanor Fenwick Hale looked at Sloan once. She took in the coat, the shoes, the hand on his sleeve, and then she lowered her eyes to the folder in front of her with the calm concentration of someone reviewing a figure she had already checked twice. No visible distress, no collapse, no outrage, nothing remotely useful to the performance he had brought with him. That should have unsettled him. It did not yet, because Grant had spent most of his marriage misunderstanding Eleanor in ways that felt to him like intelligence. He had mistaken stillness for weakness, courtesy for dependence, elegance for fragility. And because Eleanor had never found it necessary to correct him noisily, he had reached the conclusion that men like Grant often reach about women like Eleanor, that refinement is a form of softness. He was wrong about that. He was wrong about several other things, too, because Eleanor was not waiting for Grant to confess. She was waiting for him to commit himself to paper. And he did. If you enjoy intelligent courtroom stories where evidence matters more than emotion, subscribe to the channel. We bring you a new legal drama every week. Now, back to Grant Hale. 9:34 a.m. Judge Lydia Shaw took the bench. The courtroom on the 4th floor smelled faintly of old wood, institutional coffee, and radiator heat. The morning docket was routine. The case was not. Grant's attorney, his cousin Calvin Hale, rose first with a preliminary motion to restrict the scope of financial discovery. His argument was polished, confident, and built on a version of reality that would not survive the next 40 minutes. Eleanor sat beside August Weller, her attorney, a man who had represented Fenwick fiduciary interests for 2 decades and had the particular stillness of someone who never needed to raise his voice because the record generally did it for him. August did not object to Calvin's motion. He did not interrupt. He wrote nothing down. He waited, because what was about to happen in that courtroom had actually begun 6 months earlier, in a compliance packet Eleanor had almost overlooked on a Tuesday afternoon while her children did homework upstairs. To understand why bringing Sloane Mercer to court became the most expensive decision Grant Hale ever made, you have to understand what he thought he knew about his wife, and what he had never once bothered to learn. Most people search for betrayal in conversations. Eleanor had spent her career finding it in signatures. Eleanor Fenwick was born into one of those families whose names circulate constantly in rooms where power is actually arranged, and almost never in rooms where power is merely discussed. The Fenwicks were not performative rich. They were infrastructural rich. Trusts, foundation boards, municipal finance, private institutions, land conservancies, quiet advisory relationships with louder people who preferred someone else to carry the math. Her father, Benedict Fenwick, had spent 40 years turning a narrow trust practice into one of the most quietly influential legal operations in the Northeast. His work did not make headlines because it existed one level beneath headline making. If a university survived a donor fight, if a city structured pension exposure without a scandal, if a family office avoided implosion after the founder died without clarity, there was a decent chance Benedict Fenwick, or someone trained by him, had touched the paper. Eleanor's older sister, Rosalind, inherited the visible steel in the family. She became a restructuring attorney. The kind boards called when they wanted companies saved and the weak people removed from it. Eleanor chose something narrower, and to people who did not understand it, gentler. She went into fiduciary forensics, not routine accounting, not tax planning, the work underneath wealthy conflict, tracing beneficial ownership, finding concealed value, identifying where a person had signed one version of reality while funding another. It was technical, dry, and almost perfectly suited to her temperament. She did not like drama. She liked proof. Then she married Grant Hale. At the time, the match made a kind of sense that later became difficult to explain to people who only knew the ending. Grant was handsome in the polished urban way that photographs well and ages later than it should. He was commercially ambitious. He had taken a middling redevelopment company and turned it into something regionally significant by understanding two things very well: how cities wanted to sound when they approved controversial projects, and how investors wanted to feel when they funded them. He was also, Benedict noticed almost immediately, a man who treated high-trust environments as opportunities for strategic extraction. Benedict did not object to the marriage. That was not the same as approval. Eleanor saw in Grant something she did not name out loud for years. He was not merely vain. Vanity is common and often survivable. Grant had something more acquisitive than that. Whenever he encountered another person's steadiness, especially if it outranked his own, he did not simply want approval. He wanted to use it. He wanted proximity to legitimacy, without ever fully submitting to the standards that created it. Still, marriages are not built from diagnosis alone. For a time, theirs worked well enough on the surface. 2 children, a substantial house in Chestnut Hill, the right dinners, the right boards, a husband building projects with civic language around them, a wife who had stepped back from formal practice after their second child, but continued reviewing trust matters for her family from home. This mattered more than Grant ever understood, because in his version of their marriage, Eleanor had stopped working. In reality, she had merely stopped explaining her work to him, and the difference between those two things became the most important fact in this story. It was a Tuesday in October when the first crack appeared, not in the marriage, in the numbers. Eleanor was reviewing a tax credit compliance packet for one of Grant's riverfront redevelopment projects. It was routine, the kind of document she sometimes reviewed informally, because it touched family tax exposure. Inside the packet was a line item reference to something called Community Trust Alignment Support, routed through a vendor family she had never seen before. The amount was unremarkable. The routing sequence was not. The consulting entity sat between two Hale subsidiaries in a way that made no operational sense, unless its purpose was not advice, but passage. Eleanor did not react. She did not confront. She did not call her father or her sister or her lawyer. She wrote down the vendor identification number on the back of her son's permission slip, set the compliance packet aside, and finished making dinner. That night, after the children were asleep, she returned to the kitchen table with her laptop and a cup of tea that went cold within 20 minutes. 2 days later, she had the vendor tree. A week later, the Delaware layering. By the end of the month, she understood enough to know two things. First, Grant was funding something that was not business. Second, he was using paper sophisticated enough to protect him from ordinary scrutiny, and not nearly sophisticated enough to protect him from her. She had not yet found the affair. She had found the routing structure. And there is a difference. Affairs leave messages. This left accounting entries. The woman sitting quietly behind Grant that morning in court had not started as his mistress. She had started as a line item. Sloan Mercer joined Hale Redevelopment Partners as Director of Civic Partnerships at 31. She was polished, articulate, and very good at the performance layer of morally ambiguous business. She could stand at a podium and make displacement sound like opportunity. She could soften an investor breakfast, sharpen a council presentation, and make an aggressive redevelopment timeline feel almost philanthropic. Grant liked her because she was useful. Then he liked her because she admired him visibly. Then he liked her because she wanted something from him and was not subtle about it. The affair began the way Grant did most things that would later become structural problems for him, through vanity disguised as convenience. Eleanor knew within months, not because of lipstick, not because of perfume, not because she checked his messages in the middle of the night. She knew because Hale Redevelopment's expense summaries began showing a category of stakeholder hospitality with the rhythm of intimacy rather than business. 3 dinners in 12 days. A hotel suite in New York attached to no conference code. Car service returns too late for the public events they were supposed to accompany. Pattern. Eleanor had spent enough years near concealment to know that behavior tends to become numerical before it becomes visible. Intimacy changes expense patterns the way gravity bends light. You do not see the object directly. You see what it does to everything around it. She said nothing, not because she was frightened, because she was watching. And if you think the affair was the real scandal, it was not. The affair was only the visible part. The money was the story. Because Grant made a second mistake after first. He started moving money. Not crudely. He was too experienced for that. He used project reserves, community engagement allocations, consultant retainers, special purpose entities attached to redevelopment parcels, small enough to read like ordinary complexity, large enough over time to matter. Hale Redevelopment Partners controlled a web of project LLCs, each tedious enough on paper to discourage curiosity. Through those entities, over roughly 20 months, Grant began redirecting value out of the marital estate and into channels he assumed would become difficult to unwind once divorce began. The central mechanism was elegant enough to flatter the person who designed it, and stupid enough to destroy him once it was seen clearly. One Hale subsidiary entered a standing civic advisory arrangement with a consulting entity called Holloway Public Strategies. On paper, Holloway was a public engagement firm providing outreach strategy on sensitive redevelopment matters. In reality, it was a transfer basin. Money entered as project expense. Money settled as protected value. And Holloway Public Strategies had exactly one characteristic that mattered: its beneficial owner, concealed through 2 Delaware formations and a nominee signature layer, was Sloan Mercer. Eleanor found Holloway 3 weeks before Grant pushed the postnuptial agreement. The discovery came over something so small most people would have missed it entirely. The same compliance packet from the Riverfront project, the vendor identification number she had written on the back of her son's permission slip, led to a consulting entity that sat between two Hale subsidiaries in a way that made no operational sense. She traced the entity registration to Delaware, then through the nominee layer, then to a banking compliance file that required beneficial ownership certification. And there, on page 2, in a document that was never supposed to surface inside a marriage, was a name Eleanor recognized. Not from a text message, not from a rumor, not from a friend's whispered phone call, from an expense report. Sloan Mercer. That was the moment the story changed categories. It was no longer a marriage with an affair. It was a marriage with an architecture. Grant was not simply cheating. He was engineering. He was building a financial structure designed to survive divorce, with his mistress as a concealed beneficiary, and his wife as the person whose share would quietly shrink once the numbers were sufficiently buried. Grant's confidence came from a common rich man error, mistaking complexity for invisibility. He believed that enough layering would make the structure unreachable. He was not counting on Eleanor, because Eleanor did not react like a betrayed wife. She reacted like a forensic examiner who had just found a filing discrepancy in a trust audit. She cataloged. She cross-referenced. She built a timeline. And she told no one. Not yet. The post-nuptial agreement was Grant's idea. He framed it the way he framed most things designed to benefit himself, as shared prudence, business insulation, asset clarity, protection from future misunderstanding. He sat Eleanor down one evening after the children were in bed and explained that his projects were entering a more complex phase. That exposure was increasing, that it would be responsible for both of them to formalize a boundary between marital property and business holdings. He used the word responsible 3 times. Eleanor counted. His lawyer, his cousin Calvin Hale, drafted the agreement heavily in Grant's favor. It limited Eleanor's claims on multiple business holdings. It affirmed Grant's sole ownership of several redevelopment entities. It defined an expansive schedule of separate and excluded property attached to his commercial interests. The language was dense enough to feel thorough. The intent was plain enough to feel aggressive. And buried inside the ownership schedule, listed among dozens of entities Eleanor was being asked to waive claims against, were the subsidiaries through which Holloway Public Strategies had been funded. Grant wanted those entities classified as his loan. He believed that by fixing sole ownership before divorce, he could isolate the value inside them from any future marital claim. What he did not understand, because he had never respected Eleanor's expertise enough to fear it, was that sole ownership does not only protect assets, it assigns consequences. Eleanor read every page. She read the ownership schedule twice. She read the liability provisions 3 times. And then she signed it. Calvin Hale watched her sign with the faintly satisfied expression of a man who believed he had just completed something clever on behalf of his client. Grant watched her sign with the quiet triumph of a man who mistakes compliance for surrender. Neither of them noticed what Eleanor's face actually said, because Eleanor smiled, not nervously, not bravely, not with the tight resignation of a woman accepting defeat. She smiled the way a person smiles when a document has just become more useful than the person who drafted it intended. Then she capped the pen, slid the agreement back across the table, and said to Calvin Hale very quietly, "Keep that somewhere organized, Calvin. We may need the exact language." Calvin blinked, nodded once, and moved on to signature notarization. Grant remembered that line much later. At the time, he heard only composure. He should have heard warning. Eleanor took the file to her father on a Friday afternoon. Benedict was in his study, a room lined in old books and practical discretion. He read without interruption for almost 20 minutes. the compliance packet, the vendor tree, the Delaware formations, the beneficial ownership certification, the expense patterns, and now the post-nuptial agreement with its detailed ownership schedule. He set the papers down and removed his glasses. How long have you known about the woman? Since before the vendor structure, Eleanor said. And the structure? Long enough. He folded his glasses slowly. Do you want him embarrassed? Benedict asked. Or do you want him pinned? There was no softness in the question, only scale. Eleanor looked toward the window. He thinks the affair is the injury, she said. It is not. The injury is that he believed he could build concealment inside a marriage and assume my name would make it cleaner. Benedict nodded once. Then do not interrupt him before he files something under oath, because he will move the paper. Yes, Benedict said, and because lies told at dinner can be denied. Lies signed become structure. Rosalind found out the way Rosalind found out most things worth knowing, without being told directly. She stopped by Eleanor's house one evening with draft language for a family land matter and found 3 pages of entity mapping half covered beneath a legal pad on the breakfast table. She read them standing up. Then she sat down. How bad? Bad enough. Bad enough for divorce, or bad enough for collateral damage. Eleanor looked at her sister. Rosalind understood immediately. Fine, she said. Then we do this properly. Eleanor could not predict Grant's every move. She did not need to. She only needed him to keep behaving like himself. And Grant, behaving exactly like himself, filed for divorce 11 weeks later. Of course he filed first. Men who mistake motion for control almost always do. Grant filed his petition on a Wednesday morning in March. He filed the way he built projects, aggressively, with expensive confidence, and with the assumption that whoever moves first controls the frame. Calvin Hale prepared the petition with the careful polish of a man who understood courtrooms primarily as rooms where presentation outweighed precision. The strategy was layered. Temporary restriction of spousal support based on constrained business liquidity. Limited access to financial discovery on the grounds that business records were proprietary and operationally sensitive. Narrow interpretation of firm value tied to current project exposure rather than underlying asset worth. Early pressure designed to force Eleanor into a smaller settlement before anyone had time to get comfortable inside the books. On paper, it was skillful. The disclosures were conservative without being absurd. The entities were dense without looking theatrical. Holloway public strategies appeared, but only in fragments. References, expense pathways, project support language, never as what it actually was. Grant's picture of reality was this: a developer under financial pressure, burdened by an over-leveraged portfolio, offering a fair but necessarily limited settlement to a wife who had not worked in years and whose claims should reflect present liquidity rather than speculative value. It was a story told in numbers. And like most stories told by men who believe their own accounting, it was incomplete in exactly the places that mattered most. Eleanor received the filing through August Weller's office. She read it at her kitchen table before sunrise while coffee cooled beside her and the house was still dark upstairs. She read the disclosure schedule first, then the asset summary, then the entity list. She did not react the way Grant expected a woman to react upon being served divorce papers by a cheating husband. She reacted the way a forensic examiner reacts when a subject submits a document that contradicts what she already holds in a separate file. She picked up the phone and called August. He arrived at 11. Read for half an hour without speaking. Then he said what Eleanor already knew. He is not cautious enough. No. He thinks complexity is the same as opacity. Yes, August tapped the disclosure schedule with one finger, and he filed before discovery forced him to be cleaner. He wanted initiative. August nodded slowly. He has given us something better than initiative. He has given us sworn incompleteness. That phrase mattered. In family court, sworn incompleteness is not a technicality. It is a credibility event. Once a judge believes that financial disclosures were deliberately narrowed, every number the petitioner presents afterward enters the room already distrusted. And distrust, in a division of assets proceeding, is not an emotion. It is a multiplier. August closed the filing. He listed the subsidiaries, most of them, including the ones that fund Holloway, fragments, enough to trace, not enough to be called transparent. Good. Eleanor looked at him. Good? If he had disclosed Holloway fully, August said, we would be arguing about interpretation. Because he buried it, we will be arguing about concealment. And concealment in front of this judge is a much more productive conversation. The temporary hearing was set for a Monday morning in April. Grant intended to use it not only to limit Eleanor's financial leverage, but to define the emotional architecture of the case before substantive discovery could begin. He had spent years believing that whoever controlled the room controlled the result. 3 days before the hearing, he made a decision that would follow him through every negotiation, every conference, and every settlement conversation for the rest of the case. Sloan would come to court. Calvin objected, not strongly enough to matter, but enough to preserve later deniability. This is family court, Grant. It is optics. It is a judge. It is a room. That sentence should have warned Calvin more than it did. A room, to Grant, was not a place of evaluation. It was a place of influence. He believed if Sloan sat where Eleanor could see her, if the message of replacement entered the proceeding before the first argument, then some part of the case would already be won. He also intended to call Sloan as a witness, not as a mistress, as a polished executive, a reasonable professional affected by the respondent's irrational conduct toward the business. He thought it was elegant. He thought wrong. The documents were about to stop supporting him. They were about to start testifying. Because at 9:34 on that Monday morning, Judge Lydia Shaw would take the bench. At 9:43, Calvin would call his witness. At 9:47, August Weller would stand up, open a slim charcoal folder, and say the name of a company that Sloan Mercer had not expected to hear under oath. And by 10:02, the first ownership document would reach the bench. Grant entered that courtroom believing he controlled the narrative. By the time he realized the courtroom was no longer listening to his story, it was reading his paperwork. 9:34 a.m. Judge Lydia Shaw took the bench. The courtroom on the fourth floor smelled faintly of old wood, institutional coffee, and radiator heat that had outlasted 3 renovation budgets. The morning light came through high windows at an angle that made everything feel slightly overexposed. Shaw was not a dramatic judge. She did not perform authority. She carried it in pauses, in the removal of her reading glasses, in questions that arrived without warmth and landed without exit. Lawyers who had appeared before her more than once knew 2 things. First, she read everything before the hearing began. Second, she remembered what you said last time. She looked at the room. She looked at Grant. She looked briefly at Sloan seated behind counsel table. Then she opened the file. Calvin rose first. He argued with expensive confidence. Hale Redevelopment, he explained, was under meaningful financial strain. The respondent was seeking sprawling access to business records far beyond anything necessary for temporary relief. Current disclosures were substantially compliant. The court should restrict further discovery, calibrate temporary support to actual present liquidity, and avoid turning a family matter into a corporate audit. It was a well-built argument. Clean sentences, reasonable tone, strategic framing. It also depended entirely on the assumption that the disclosures were honest. Judge Shaw listened with the expression of a woman who had heard bad faith dressed in better vocabulary. She made one note. She asked no questions. That should have concerned Calvin more than it did. Then Calvin called his witness. Your Honor, The petitioner also wishes to present testimony from an employee with direct knowledge of recent disruption to firm operations caused by respondent's conduct. Judge Shaw looked up. What employee? Ms. Sloan Mercer, Director of Civic Partnerships. A silence moved through the room. Small, but structural. Judge Shaw's eyes went first to Grant, then to Sloan, then back to Calvin. August stood. No objection, Your Honor. Calvin actually blinked. None? None, August said calmly. We would be very interested in Ms. Mercer's testimony. 9:43 a.m. Sloan Mercer took the stand. To her credit, she began well. Calm voice, controlled posture, elegant suit, no visible signs of panic. Calvin led her carefully through a prepared narrative. She was a senior employee. She had observed instability. The respondent had made contacts within the firm that created unease. Project communications had become difficult. There was concern about reputational harm. It was a professionally laundered version of a very old story. The wife is emotional. The mistress is competent. The husband is burdened. The business is suffering. Judge Shaw listened. August wrote nothing. When Calvin sat down, quietly pleased with himself, Judge Shaw looked to the other table. Mr. Weller. 9:47 a.m. August Weller rose with a single slim folder. He crossed to the lectern with the unhurried calm of a man who did not intend to ask many questions because he would not need many. Ms. Mercer, he said, you are Director of Civic Partnerships for Hale Redevelopment Partners. How long have you held that role? Just over 2 years. And your work includes project messaging, stakeholder relations, community engagement, and advisory coordination? Yes, advisory coordination, August repeated mildly. Useful phrase. Sloan hesitated almost imperceptibly. August opened the folder. Ms. Mercer, are you familiar with an entity called Holloway Public Strategies? That was the moment the temperature changed. Not loudly. Courtroom shifts are rarely loud. They sharpen. Grant went still. Calvin looked sideways toward his client with a first clear sign of genuine uncertainty. Sloan's expression did not collapse. It tightened. I am aware of it, she said carefully. In what capacity? It provides consulting services connected to public engagement work. For Hale Redevelopment? For a number of clients. A number, August said. Name one. Calvin rose. Relevance. August did not turn. Your Honor, the witness has been offered as an operational witness concerning the effect of respondent's conduct on petitioner's business. I am entitled to explore the scope and nature of that operational relationship. Judge Shaw nodded once. She may answer. Sloan did not answer, because she could not, or could not safely. I do not manage the full client roster. Of course not, August said. Then let's narrow it. He handed a document to the clerk. Respondent's Exhibit 7. Beneficial ownership certification attached to a banking compliance file for Holloway Public Strategies. Calvin took the copy, glanced down, then looked up far too quickly. The room was about to hear a name read aloud that would change the trajectory of the entire case. Not because it was shocking, but because it was signed. And in a courtroom, the difference between an accusation and a fact is a signature. 9:51 a.m. August's voice remained almost conversational. Ms. Mercer, please read the name listed on page 2 as the beneficial owner. Sloan stared at the paper. The courtroom waited. She looked once at Grant. Grant did not move. Calvin stopped writing. Judge Shaw lifted her eyes from her own copy. Read it. Sloan swallowed. Sloan Mercer. No one in the room moved. Not the clerk. Not the bailiff. Not Calvin, who had gone very still in the particular way lawyers go still when they realize they have been building a case on behalf of a client who has not told them everything. August let the silence stand exactly long enough to become structural. Then he continued. And Holloway Public Strategies has received approximately $13.2 million in transfers from Hale redevelopment project entities over the last 21 months. Correct? Calvin was on his feet. Your Honor. August did not pause. Those transfers were described variously as civic alignment fees, community transition support, public interest consulting, and project messaging stabilization. Correct? Sloane's composure thinned visibly. Yes. 10:02 a.m. Judge Shaw lowered her eyes to the exhibit, then raised them. Mr. Hale, she said, not yet as a question, which was somehow more dangerous. August went on. Ms. Mercer, does Holloway Public Strategies pay the lease on the apartment you occupy on Marlborough Street? Objection, Calvin snapped. Harassment. Judge Shaw did not even glance at him. Overruled. The pause before Sloane answered became its own kind of evidence. Yes. And does Mr. Hale stay there? Yes. August handed up a second document. Respondent's Exhibit 9. Wire authorizations bearing petitioner's digital approval for 3 Holloway transfers executed from petitioner's home office network on evenings, when petitioner was publicly attending charitable events with respondent. Grant finally looked at Eleanor. That was the moment he understood. Not all of it. Not yet. But enough. Enough to know that whatever he had assumed about her knowledge, he had assumed too little. And enough to know that whatever he had assumed about her passivity, he had confused patience with permission. August did not press the adultery. That was the part Calvin had expected and prepared for. Instead, August did something much worse. He returned the paper. Your Honor, petitioner seeks temporary determinations based on constrained liquidity and reduced business value. Petitioner has also chosen to place Ms. Mercer before this court as a business witness. These transfers are therefore directly relevant to whether marital assets were diverted through a related party entity beneficially controlled by petitioner's intimate partner. There are sentences that alter hearings in real time. That was one of them. Calvin tried to recover the room. This is a divorce proceeding, he said sharply. Counsel is attempting to transform it into a corporate fraud hearing. For the first time that morning, August looked directly at him. No, he said quietly. Your client did that when he moved money through his mistress and then brought her in to authenticate the relationship. Then August delivered the piece that made the postnuptial agreement finish what Grant himself had started. Your Honor, respondent asked that the court take judicial notice of the parties' postnuptial property schedule already submitted with petitioner's motion for enforcement. He paused. Petitioner insisted that multiple project entities, including the subsidiaries through which Holloway was funded, were his sole and separate property. Respondent waived any ownership claim to those entities in writing. Another pause. The liabilities attached to their conduct are therefore as singular as the ownership petitioner demanded. Calvin's face changed. He understood then what Eleanor had understood 16 months earlier. The postnup Grant believed would narrow her claims had also fixed his ownership. Soul means soul. Assets, yes, but liabilities too. He had built a wall to keep Eleanor out, and now he was locked inside it. The documents were no longer supporting him. They were testifying. 10:19 a.m. Judge Shaw called a 20-minute recess. When she returned, the ruling was brief and ruinous. She denied Grant's motion to restrict discovery. She denied his request for support limitations based on existing disclosures. She ordered immediate supplemental production on all Hale redevelopment transfers to outside consulting entities over a 2-year period. She restricted unilateral movement of certain business funds pending further review, and then she said the line that followed Grant through every negotiation afterward. The court has serious preliminary concerns regarding the reliability and completeness of petitioners' financial representations. Family lawyers hear that sentence and understand what it means instantly. Credibility damaged, leverage altered, patience shortened. Every future statement now enters the room already distrusted. 11:17 a.m. The hearing ended. Grant Hale left the courtroom with less credibility than he had entered with. His mistress left separately, her face pale enough to look almost translucent. His lawyer left without speaking to him. And Eleanor Fenwick Hale capped her pen, closed her folder, and walked out the same way she had walked in, quietly, without spectacle, without triumph, because this was never about winning a room. It was about completing a record. Grant did not approach Eleanor immediately. He waited until the room had thinned, until Calvin was conferring with a paralegal near the aisle, until Sloane had disappeared into the hallway with her phone in one hand and her composure in neither. Then he crossed to Eleanor's table. She was returning papers to her portfolio with exact, economical movements. When she looked up, he still looked like Grant Hale in the formal sense. Well-dressed, controlled, photogenic, even in failure. But something central had left him. He no longer looked dominant. He looked documented. You knew, he said, it was not exactly an accusation, more the bewildered statement of a man locating the point at which his own narrative had ceased to belong to him. Yes, Eleanor said. How long? Long enough. He glanced toward the hallway where Sloane had gone, then back. You let this happen. That sentence carried all the moral self-pity of a man newly offended by causality. Eleanor stood. She was not tall, but composure has its own dimensions. No, she said. I let you continue. You could have confronted me. I could have. You could have ended this privately. I could have. Then why did you not? It was the closest he would ever come to asking the only question that mattered. Why this way? Why the record instead of the tears? Eleanor held his gaze. Because if I confronted you before you signed anything, Grant, you would have lied socially and moved the paper. I needed you to commit to a version of yourself in writing. She paused, adjusted her coat. You should have left her outside. Grant closed his eyes for 1 second. Not long enough to be dramatic, long enough to register impact. August appeared beside Eleanor with perfect timing. The clerk needs your acknowledgement on the supplemental order. Grant stepped back. That too was noticed. Power is often measured by who yields space first. Discovery widened after that with the weary inevitability of poor architecture meeting weather. Holloway Public Strategies was not the only basin. It was simply the one Sloane had helped authenticate under oath. There were others, smaller, less personal, deferred consulting agreements, front-loaded advisory fees, community benefit reserves that appear to benefit almost no community at all. Not every irregularity was criminal. The law is often less dramatic than the guilty deserve. But divorce does not require criminality to become devastating. Marital dissipation is enough. Sign concealment is enough. Loss of credibility in front of the judge is more than enough. Sloane hired separate counsel within 10 days. She gave a sworn statement distancing herself from the structural design and attributing the entity architecture to Grant and his finance team. She did not make herself noble. She made herself useful. That was enough. Calvin Hale withdrew 2 months later. Officially, strategic disagreements. Unofficially, he had no appetite for attaching his name to a client who kept discovering new facts about his own case after every disclosure deadline. The settlement conference arrived in October. By then, the emotional center of the case had narrowed, not because betrayal becomes simple. It does not, but because documentation has a way of removing mythology from suffering and leaving only the workable arithmetic behind. The conference took place in a private courthouse suite. No gallery, no audience, no Sloane, just lawyers, numbers, and the dry fatigue of a man who had spent 6 months learning that charm has almost no exchange rate in a settlement room. Eleanor kept the Chestnut Hill house. She received a major compensatory distribution tied to diverted marital funds. She secured educational trust protections for the children beyond Grant's unilateral control. She obtained indemnity language shielding her from future tax or regulatory consequences arising from entities he had designated his sole property. And perhaps most importantly, she locked him into continuing disclosure obligations severe enough to make any future concealment a logistical punishment. When it was Grant's turn to sign, he did so without speech, without bitterness polished into dignity. Just a signature place where his collapse had finally narrowed into arithmetic, because in the end he signed again, not because he was honest, because arithmetic had finally made dishonesty more expensive than surrender. Years later, people still told the story, not always accurately. The heels grew higher, the paws longer, the mistress more glamorous, the husband more foolish, the courtroom more visibly stunned than it probably was. But among the people who had actually been there, the version that lasted was simpler. They remembered that he brought her in. They remembered that Eleanor did not react. They remembered August Weller asking, in a voice so calm it made the answer fatal, whether Sloan Mercer was familiar with Holloway public strategies. And they remembered one thing above all, not triumph, not vengeance, not the spectacle Grant had come there to stage. They remembered the expression on Eleanor Fenwick Hale's face when the first ownership document was handed to clerk. Recognition, the look of a woman watching a door close exactly where she had always known it would. Grant Hale had spent 12 years believing his wife was merely elegant. He walked into court with his mistress on his arm and learned too late that elegance, in the right hands, is often just precision wearing better clothes. Courtrooms rarely destroy people. Their own records usually do that first. If you enjoyed this courtroom story, subscribe for more premium legal dramas.